Date cases item 37 BA 5252 of 2026.
FIR पड़ी गंदा FIR है ना. Just see the kind of allegation your wife has made against you.
Absolutely matrimonial dispute.
Matrimonial नहीं है. It is not just matrimonial. There is much more to it. Read it. पढ़ी.
Page 16. मैं शाहिद परवीन और गुड़िया पति शहनवाज अहमद निवासी आजाद नगर पोस्ट शिवांडी स्वयं मैं निवेदन करता हूँ कि बोकारो क्षेत्र में यह मेरा पति कुख्यात अपराधी शहनवाज अहमद पिता जहार अहमद निवासी स्वयं 30 मार्च 2026 को लगभग 10:30 बजे रात में मेरे फर्स्ट गेट में ताला लगा हुआ था. उसे धक्का देकर तोड़कर घुस गया. उसके साथ कोलकाता का एक घोषित गुलाम मुस्तफा स्वयं उसकी बहन सफा खान पति शहनवाज अहमद एवं अन्य को बुलाया. इन लोगों को ने अपने पहले घर में पूरा कैमरा तोड़ दिया. उसके बाद पूरा गुंडे किया. हत्या करने का फिराक में था. इसकी सूचना रात्रि में समूह को दिया. कॉल करके इमरजेंसी नंबर पर भी किया. तब पुलिस आई तो पुलिस के आने में उनके सामने से फरार हो गया. ये लोग सुनियोजित तरीके से षड्यंत्र हत्या करना चाहते थे. कुख्यात अपराधी शहनवाज अहमद मूल निवासी खालिशपुर सीवान बिहार का है और अपने गुरुओं के साथ लगातार मेरे पूरे परिवार के साथ गंभीर अपराध करते आ रहे हैं. इनके विरुद्ध कई हत्याएं लूट और अन्य का गंभीर मामला बन गया. इन पर सीसीए का कार्रवाई भी हो चुका है. क्षेत्र में इनकी भारी दहशत है. शहनवाज अहमद ने वर्ष 2017 में मेरे साथ घर में घुसकर हथियार अपने बंदूक के साथ जबरदस्त स्वयं किया. हमारे और हमेशा जबरन संबंध बनाए रखने के इसके अवैध संबंध मेरा 3 वर्षीय पुत्री अर्श अहमद पैदा हुई जिसकी पुष्टि से की जा चुकी है. पुत्र के जन्म के बाद उसने मुझसे निकाह किया और इसके अपने आजाद नगर घर के पर ले जाकर बंद करके रखता था और मारपीट भी करता था. सुबह में भी अपने घर पर कई बार लेकर गया. मुझे रखा. यह व्यक्ति बेहद स्वभाव का बहुत गंदा आदमी है. इसे कई महिलाओं के साथ तो मुझे रखा है. यह बेहद इनके कई महिलाओं और बच्चों की जिंदगी बर्बाद किया. गुंडा लोग के दहशत के कारण कोई डर से नहीं बोलता है. इसलिए मेरी पुत्री के साथ भी गंदा काम किया. इसके गंदे कृत्य का मेरे मोबाइल के प्रमाण का था. इसलिए मोबाइल को पटक कर इसने तोड़ दिया. इसके प्रमाण मेरे पास है. वो बार मुझे तलाक कहकर 3 तलाक की धमकी देता है.
बहुत एलिगेशन है.
लॉर्डशिप काइंडली वन लाइन. मेरे नाबालिग पुत्री के साथ भी गंदा काम किया. Annexed 2 में काइंडली सी.
What is it?
Annexed to the statement of that girl जिसके साथ ये वो केस हुआ था, गलत काम किया है, उसका स्टेटमेंट है Annexed to page 23 जिसमें हुजूर पढ़ रही थी. मैं पढ़ता हूँ. मैं इस केस का पीड़िता हूँ और सूची मेरी माँ है. दैट इन्फॉर्मेंट. मेरा जन्म घर में ही हुआ था. मेरा जन्म प्रमाण पत्र नहीं बना. ARS पब्लिक स्कूल LH मोड़ बोकारो में मैं कक्षा 8 में पढ़ती हूँ. इस स्कूल में मैं छात्र पहचान की पत्र की मूल प्रति लाई हूँ जिससे मेरी जन्म तिथि स्वयं है. अंकित है. So she is having to try malign me, lordship, in several cases. Therefore, lordship, this that FIR which has been
20
lost.
केसेस आपके अगेंस्ट में यही फाइल किए हैं क्या?
उसमें 3 केस ये फाइल के 3-4 केस ये फाइल की हुई है जिसमें इस केस में मेरा एक्विटल हो गया है. पॉस्को केस नंबर 63/2005 25 और 3 केस जो है 2 केस जो है लगातार उसी दिन का केस है. 20 केस.
ट्रायल का क्या स्टेज?
चार्जशीट फाइल हुआ है, अभी तो ट्रायल स्टार्ट नहीं हुआ।
विक्टिम का ये इंफॉर्मेंट का गवाही होने के बाद आई, उसका गवाही होगी, ये तो खत्म ही हो जाएगा कहानी।
नहीं कुछ रखा होती है। That liberty will be
BA number 5253 of 2026. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petition submits that the case primarily arises out of matrimonial dispute, and his wife is the informant of the case. The charge sheet has already been submitted.
Yes.
The learned counsel submits that there are 20 criminal antecedents against the petitioner.
Out of lordship that 10 cases I have been acquitted.
And in 10 cases, the petitioner has been
acquitted. In one case, my name is, I am not the accused. In another case, I am bailed. And one case, charge sheet has final formalities.
That's right. The learned counsel for the state has opposed a prayer for bail and has submitted and has placed the FIR and has submitted that there are serious allegations made against the petitioner, and the petitioner by itself is a threat to his wife and other family members. The victim is yet to be examined after hearing the learned counsel for the parties and considering the nature of allegation made in the FIR itself. This court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after the victim and her family members are examined before.
Item 38, BA 5436 of 2026.
Statement under section 153 was moved. During the victim has stated that she is born with the Molila Sa. On her only says major and she is already married. Present petitioners
The
are
entire house and belongings of the informant was also burnt.
no, only to make the case
It was not burnt.
only
I just want to know if it was not, there is a separate section for
Yes,
burning the
yes.
house.
I got the photograph.
No, no,
The
we are not
house.
on photograph. Charge sheet
house.
has been submitted under which section?
Yes, under section 4.
Yes, under which section?
Charge sheet has been submitted under section. But these petitioners are the only mama and me. The fact of the case is that the marriage of Munila Shah was already fixed with someone else, but the victim and the Munila Shah, they fled up. Thereafter, these petitioner along with the parents of the Munila Shah went to the house of the informant and suffered between them. And now the
And
matter,
burnt the house.
they make the allegation more sense.
No, no. Burning is something will be recovered at the place of occurrence.
There is nothing.
Burning is not something.
Injuries are also seen. Now the matter has been
Injuries
settled.
are also there. It was burnt or not burnt? The house
As per
of the
allegation, it was
informant.
burned, but as the photograph what I'm seeing, it is
We are
not
not concerned with the photograph. Under which section charge sheet has been submitted?
burned. Yes, it is submitted.
Under that section also,
Yes,
no?
yes.
So how do you say it was not burnt? Prima facie, upon investigation, the allegation must have been found true regarding burning of the house of the informant. Isn't it?
Now since the matter is already been, now the girl is already residing with the parents of the Munila Shah.
What was the age of the girl?
19 years. More than 19 years. It has come during investigation also, which is part of the AP law.
Yes, what do you say?
Yes, the house and all belongs were burned by the my lord
They got any specific indication against the one of this person while he was come with the weapons murder, the sword murder, and
The girl was major.
go yes, maybe.
23rd of July 2006.
It was a charge sheet file.
Charges have been filed on 16/6/2026. Thereafter, cognizance on
You are in custody since.
I am in custody since 21/4/2026. The case has been committed.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 21/4/2026 and charge sheet was filed on 16/6/2026 and the case has already been committed. He has further submitted that so far as the victim girl is concerned, she was major and she has willfully eloped with the petitioner, got married.
With one Munila Shah, not the petitioner.
Okay, with one Mulilal Shah, got married and is staying with her in-laws.
Yes. In-law.
And so far as the petitioner is concerned,
They are the mama and Jija.
petitioners are the
PW1 is mama of Munila Shah and PW2 is Jija of Munila Shah.
the two petitioners are uncle and brother-in-law
Brother.
of Mulilal Shah,
Yes.
to whom the victim got married.
Yes.
He has further submitted that the informant and others, they suffered simple injuries.
Simple.
The learned counsel for the state has opposed a prayer for bail and has submitted that even the house of the informant was burned.
But later on, the house was repaired and everything was compensated with the initial fee.
To which the learned counsel for the petition has submitted that later on the house was repaired and needful was done. After hearing the learned counsel for the parties and upon going through the statement of the victim recorded under section 183 BNSS, she has stated that she had gone with Munilal Shah on her own and got married with him. And she does not want to contest this. Considering the statement of the victim recorded under section 183 BNSS and the charge sheet having already been submitted, the petition is directed to the
Item 40, DA 6388 of 2026.
The petitioner will be getting a case that for 69 of business. It has been delayed because rising out of the initially where a complaint was filed to percent for the investigation. During the complaint, she has alleged that she has become friendly with the present petitioner from 2019, being aged over 33 years, and was teaching in a school in Patna, where both have become friends. Subsequently, it has been alleged during a month of 25 June 2023. This petitioner has come to her house situated at Sindega and has established physical relationship with her on the pretext of marriage. And thereafter he returned and they continued with the relationship. But in the 2025, in 2026, he refused and therefore this case has been dismissed.
So you're for the informed?
Yes.
Incident you are in relationship since 2019?
No,
As per the FIR itself,
2023
2019.
जब
पटना गई थी।
टीचर पढ़ते थे पढ़ाते थे जान पहचानते लेकिन घटना 23 की है जब फोर्सफुल सेक्सुअल रेप करने का एलिगेशन है स्पेसिफिकली एंड देयर आफ्टर डिसीटफुल मींस से जो है कि स्पेसिफिकली कि मैरिज ऑन प्रीटेक्स्ट ऑफ मैरिज इसी का ही कंटिन्यू
मेजर थे ना आप भी?
23 में जो पहली बार की घटना है दैट वाज फोर्सफुल अलॉटमेंट एंड कस्टडी भी सिर्फ 2 महीने का है। हम मेरा बस एक प्रेयर था कि कम से कम मेरा एग्जामिनेशन
First incident is in your own house.
मेरे घर में आए हैं। जब मेरे माता पिता नहीं थे, स्पेसिफिकली हम लिखे, वो लोग गए हुए थे सलडेगा, वो लोग गए हुए थे और उसी दरमियान जलडेगा गए हुए थे, और उस टाइम जो है ये जबरदस्ती बलात्कार किया। उसके बाद ऑन प्रीटेक्स्ट ऑफ मैरिज ही कंटिन्यूड टू एक्सप्लॉइट विमेन।
उसके बाद 2023 में तो आपको कंप्लेन नहीं
कोई कंप्लेन नहीं किया। पेरेंट्स आ गए थे घर में, स्टेटमेंट है कि हम लोग आए, दोनों मिले, उसके बाद हम चले गए। एक आदमी पटना से आके सिमडेगा में टाइम जान के वो करके चला गया, कोई कंप्लेन नहीं। उसके बाद 2-3 साल लगातार रहा।
चार्ज कब हुई?
चार्जशीट हुआ
कब?
30/6/26।
26/5/26 से कस्टडी। मेरा बस ये प्लान था कि सिर्फ मेरे एग्जामिनेशन तक के लिए उसको किया जाता है, कि सिर्फ कम से कम विक्टिम का एग्जामिनेशन।
आप कोई निजी प्राणी नहीं, you are an
हमसे 1 साल बड़े ही हैं।
Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that, as per the FIR itself, the victim went to Patna and there she started teaching in school. And the petitioner was also a teacher. And he came to her residence at Sindega in 2023 and forcibly established physical relationship with her. And thereafter he continued to exploit her and establish physical relationship on the pretext of marriage. The learned counsel submits that the petitioner is in custody since 26/5/2026 and charge sheet has been submitted on 30/6/2026. The learned counsel for the state and the informant have opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner based on the FIR itself is not in dispute. At this, the counsel for the petitioner has submitted that the FIR was lodged in 2026 when the petitioner refused to marry her and he was in the process of getting engaged with another girl. After hearing the learned counsel for the parties and considering the fact that both petitioner and the victim are major, and the incident and the initial incident had taken place in the year 2023 in the house of the petitioner at Sindega.
Also very important.
In a house of the informant at Sindega, and the petitioner and the victim were working at Patna. And charge sheet having been submitted, the petitioner is directed to be enlarged on.
From supplementary list for orders beautified Act and 2, first topic filing number 9795 of 2024.
This is also time was granted by this only for filing rejoinded to my lordship. My client is out of station for treatment, lordship. Therefore, I could not file the.
How much time do you need?
3 weeks, lordship. He is out of station, lordship.
The learned counsel for the parties are present. The learned counsel for the respondent prays for and is granted time by way of last indulgence till 14th of August to come to file rejoinder. Post on 18th August.
Item 3, first topic filing number 1570 of 2026.
Police. इसमें ये केस भी इंक्लूडेड है.
Yes, सारे चार cases.
One,
ये पहला बस
5 seconds. The learned counsel for the appellant has submitted a list of 14 cases which has been filed against the same impugn judge. The details are as under. Office is directed to list all these cases day after tomorrow in the supplementary process. These matters are directed to the court.
For final result item 1, first appeal 223 of 2026.
May please your lord petition. In this case, my lord will find that by the impugned order, lord, the petition filed by the defendant number 528 under order 7 rule 11 CPC for rejection of claim has been allowed, which not amounts to a decree within the meaning.
Service is complete.
I am operating on behalf of respondent number 5, 6, 7 and
5, 6, 7 and 8. What about others? Service?
8. I am appearing 9, 10 and
5, 6, 7, 8.
9, 10.
Up
9, 10 and
9, 10, 11. And 1 to 4? What about 1 to 4? As per the counsel for respond number 5, 6, 7, 8, 9, 10 and 11 are appearing. As per the office note, respondent number 3 has been served personally. Respond number 1 and 2, the notice upon respond number 1 and 2 has been received by their brother who lives jointly. And so far as respond number 4 is concerned, the notice has been received by her son and they are living jointly. In view of the office note with regard to service report of ordinary process of service, the notice upon respond number 1 to 4 is accepted as valid. So you want to argue today?
Lordship,
At this heading, mein.
lordship,
Final
finally,
yes.
by the impugned order, lordship, the petition filed by the defendant number 528 under order 7 rule 11 CPC for rejection of claim has been allowed, which amounts to a decree within the meaning of section 2 subsection 2 of the Code of Civil Procedure.
That's right.
Therefore, Lord, appeal, the instant appeal has been filed. Now, lordship, may I see the plaintiff's Lord filed partitions.
Where is the plate?
Lordship,
Plate.
that lower court record was also lordship.
Suit was for partition.
Lordship, partition. Lordship, may kindly see the prayer portion of the plate. Internal page 10.
Please let us see the nature of relief. What was the suit for?
Partition. Lordship, may kindly see internal page 10 of the plate, paragraph 17, that the plaintiff claims and is entitled to get the following relief: that a preliminary decree for partition of plaintiff's 1/3 share in the suit land mentioned in Schedule B, item number 1 to Roman 5 of the plaintiff in favor of the plaintiff, that after passing a preliminary decree, a final decree be passed by appointment of a survey knowing legal commissioner, who will measure the suit land and submit a report keeping in view of allotment and adjusting the Schedule B item number 3 and 4, and the land sold by Ram Prasad Kumar, father of the defendant number 5 to 8, in their 1/3 share and separate possession be delivered.
That's right, it was a suit for partition.
Partition.
The defendants filed a written statement on merits.
Yes, Lord. And
And when did they file their petition under Order 7/11?
Lordship mechanism. The defendant numbers 5 to 8 below, they filed petition under Order 7/11D on 17/8/2002.
17/8.
17/8 for rejection of claim on the ground that the suit is bad on account of partial partition and the suit property was previously partitioned. Lordship, this issue cannot be decided
Yes,
without
how
taking
to
evidence
decide
of
it?
both the parties.
Whether the
and my
suit is for
claim has
partial
been
partition.
Lordship, in the earlier suits, the two suits which were filed in Lordship, in that Lordship, the details were not given to Lordship. So Lordship, it is also barred by the doctrine of the provisory waiver also, Lordship, because once they have not included a certain piece.
So that will be decided at the trial, no?
All issues
Why a particular property has not been included? And what is the consequence of non-inclusion of property? And maybe that somebody is saying that it's my self-owned property. Who knows?
and Lordship, all issues have to be tracked together. Lordship, may kindly see the provision
And how this,
contained in Order 14 Rule 1. And Lordship, may kindly see the findings recorded by the learned trial.
I want to see that petition under Order 14.
Petition, Lordship, may kindly see. This is, my lord, the petition filed under Order 7/11.
So I'm looking at
For
this.
rejection of claim.
And after filing your full-fledged written statement, you come up with a plea. So that has to be filed at the threshold without entering into filing into written statement with respect to the merit.
Not only this, doubters were not made parties in the suit. Subsequently, they filed an application under Order 1 to 10 CPC and they have been implemented as defendants. And Lord, they have filed their written statement contesting the claim of the plaintiff on various counts.
Read the interim order. कहाँ का ये order? Which judge has passed this?
Lordship, may kindly see the findings of the learned trial court. Order dated 17/10/2025.
Please read.
Lordship, may kindly see the operative part of the order. Internal page, Lordship, 3. Third and page is the record.
You see, the present suit for partition filed by the plaintiff have violation of the following setting law
Law.
and must be taken into consideration.
Law.
What are points they have raised? Partial partition.
Partial partition.
Can you read that?
That the present suit for partition filed by the plaintiff have a violation of following settled law and must be taken into consideration while further proceeding. Partial partition cannot be recognized under the law proved by subsequent suit by the same plaintiff for ancestral property. Secondly, partition is not admissible or recognized under the law proved by the excluded sale deed by the plaintiff himself and by recital of sale deed, in which vendor of the plaintiff has clearly stated that a posted plot and measuring area was allotted to the share of the vendors of the sale deed mentioned above. As in other words, the second partition is not permitted. Now, Lordship, as per provision of Order 2 Rule 2 CPC, where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue
in respect of the portion so omitted or relinquished. Thus, in that regard, plaintiff has already filed for partition suit bearing number partition suit number 142 of 2016 and 194 of 2019 in respect of ancestral property by relinquishing the property in present suit, and as such subsequent suit for partition, that is present suit is not mentioned. That present suit is the suit in which was tried by plaintiff to bring within period of limitation by clever drafting, which otherwise barred by limitation. There is no question of limitation. My lord is aware that so far as partition suit is concerned, there is no limitation. There is recurring cause of action until and unless partition is met by meets and bounds. And lordship can see the findings. Findings, lordship, internal page 3. Heard and perused the record.
Yes, you justify this order. Yes, you justify this order within the contours of Order 7 Rule 11.
Yes. And
Order 7 Rule 11, only the plaint is to be seen. So tell me that plaint is barred by law.
Because there are already two partition suit which has already been filed, Your Lordship, and that regards to the same
We do
ancestral
not
property.
see as on date, since those facts, those things, have they stated that the suit was filed and they have lost? Is it mentioned in the plaint?
Lordship, it is still pending.
That's right.
That is still pending.
That's right. You have a remedy if a suit is pending with respect to the same thing. You have a remedy. You have a remedy to get them joined. You have a remedy to defer the hearing of a subsequent suit or whatever. But how the court has dismissed rejected the plaint. If you read the plaint, does it show that it is barred by any law? Even if there is gross suppression in the plaint, let's assume for it, right? Then also what is the suppression will come through written statement. And therefore, whether there is actually any suppression or not will be tried as an issue before the court. But it cannot be dismissed on account of Order 7 Rule 11. And the nature of order that your petition under Order 7 Rule 11D itself is referring to certain evidences. What do you want? This is not permissible. The judgment cannot be sustained in the eyes of simple people. Your friend is also there. Yes, what do you say?
I adopt the argument.
Argument of? He is not arguing anything. The court is arguing for the appeal. I just want you to answer to this question.
The only ground which we have taken.
They have also lost.
अभी उनको बोलने दीजिए सर अभी ऐसे बच्चे को तंग मत करिए हाँ बोलिए
Only ground which we have taken, Lordship, that since two title suit is already pending arising out of the same ancestral property, and with regard to another they have come, so therefore Lordship, that is barred, and also because they were barred by the doctrine of waiver also, Lordship, that in the suit they did not include, in the division of the property they did not include this.
See, the principle of law is that a suit is to be rejected under Order 7 Rule 11 simply by looking at the plaint. Nothing more. If on the face of the plaint it is barred by any law, then certainly it will be rejected. Is it barred by any law on the face of the plaint?
That it is not.
It is not that. It requires evidence, it requires adjudication. Maybe you have other remedies. You can amalgamate all the suits. That is also permissible. It is filed in the same court.
The same district.
सर एक तो जजमेंट दीजिएगा ना हमको जजमेंट दिखाने लाए हैं तो जजमेंट ढाल दीजिए
paragraph 14 also.
We'll ask the parties to appear before the court. And those parties who are not appearing, notice will be issued. Okay. With the consent of the learned counsel for the parties, the case is taken up on minutes. The case was admitted for final hearing by order dated 6/5/2026. The learned counsel for the appellant submits that the appeal has been filed against the order dated 17/10/2025, passed by the learned civil judge within bracket senior division bracket Roman 7 Zaribar, whereby the partition suit number 171 of 2023 has been dismissed and the plaint has been rejected by Kaimik.
Suit is dismissed and the petition filed by the defendant is allowed.
And the suit has been dismissed and the petition filed by defendant number 528 under order 7 rule 11 D of the CPC, read with section 151 of CPC, has been allowed. The learned counsel has submitted that upon perusal of the impugned order, it is apparent that the court has entered into the merits of the case and rival contention of the parties. The learned counsel has then submitted that at the time of examining as to whether the plaint is to be rejected under order 7 rule 11 D of CPC, especially the plaint has to be taken into consideration and the question of its rejection comes only when the plaint is under section 11 and order 7 rule 11 D comes only when the plaint is otherwise barred under law on the face of the plaint. The learned counsel has referred to the judgment passed by the Honorable Supreme Court, passed in civil appeal number 5622 of 2025, decided on 29th of April 2025, and has referred to paragraph 14 and has submitted that once the plaint discloses a cause of action, it cannot be shut down at the threshold. And in the same case, the plaint was rejected on the ground of limitation, and the court held that the same was a mixed question of fact. Para 13 and 14. The learned counsel for the respondents, appearing respondents, though have opposed the prayer, but during the course of hearing, it is not in dispute that certain defenses of the defendants have been taken into consideration by the learned court. It is further not in dispute that the appearing respondents in the present case, after entering appearance, have filed their respective written statements on the merits, contesting on the merits of the case, and at their instance, certain parties were also added during the court proceedings. After hearing the learned counsel for the parties and upon perusal of the plaint, this court finds that the plaint was filed, the suit was filed seeking partition, and the following reliefs was claimed. Para 17 का quote करें. The plaintiffs claimed that the schedule of the property was joint family property. And the cause of action for the suit arose in the year 2020 on various dates of demand of amicable partition, and on 5th January 2021, the date of refusal to do amicable partition by means and bounds. The defendants, after entering into appearance and after having filed their written statements on merits, stated that the plaintiff had not disclosed about other partition suits bearing number 142 of 2016 and 194 of 2019, which was filed by the plaintiff seeking partition of ancestral property. And therefore, the suit was barred under the provisions of Order 2 Rule 2. It was also asserted that the plaintiff in various sale deeds executed by the plaintiff himself, there was a recital that the sale deed was executed as per partitioned share of the vendor, and therefore it was sufficient to show that the property was already partitioned. It was also asserted that the partition suit itself was barred by limitation. Apart from the aforesaid, the defendants asserted that the plaintiff has violated the following settled law and which must be taken into consideration while further proceeding. Paragraph 5. Yeah, paragraph
And Lordship may kindly see.
In the aforesaid background, it was asserted that the suit itself was barred And therefore, the claim be rejected under Order 7, Rule 11 within bracket D of CPC. The learned a rejoinder was filed to the opposite petition, and the plaintiff opposed the petition filed under Order 7, Rule 11D, stating that it was neither maintainable in law nor on facts of the case, and the same was liable to be rejected. And the petition itself was against the pleadings of the defendant number 5 to 8, which they had filed by way of written statement. The learned court entered into the merits of the plea raised by the defendants in the petition filed under Order 7, Rule 11 within bracket D, which specifically dealt with the case of the defendant number 5 to 8 as asserted therein, and ultimately held that the plaintiff has already filed suit for partition, bearing partition suit number 142 of 2016 and 194 of 2016 in respect of ancestral property by relinquishing the property in the present suit. And the suit was pending, and ultimately held that the present suit itself was not guilty. The findings of the learned court is quoted as under. This court is of the considered view that the learned court was not justified in considering the defense of the defendant number 1 to 5 to 8, and also their allegations while considering the petition filed under Order 7 Rule 11 within bracket D. As indicated earlier, and from the perusal of the plaint itself, it is apparent that the plaint disclosed a cause of action, and so far as the points raised by the defendants in their petition under Order 7 Rule 11 with bracket D is concerned, the same was essentially a matter of defense and a matter of evidence which was required to be adjudicated at appropriate stage. The learned court has completely misdirected itself while holding that the suit itself was barred, the plaint was fit to be rejected, while allowing the petition filed under Order 7 Rule 11 within bracket D of CPC. Accordingly, the impugn order dated 17/10/2025 passed in partition suit number 171 of 2023 by the Court of Learned Civil Judge within bracket Senior Division Roman 7 Hazaribagh is hereby set aside, and consequently the suit revives, which is to be decided on the basis of the issues to be framed, depending upon the written statement, plaint and the written statement filed by the respective parties. Since the suit revives, the petitioner, who is the plaintiff, and the respondent number 5 to 11, who are already represented by counsels, are directed to appear before the court. I'll give a date for your appearance. And upon their appearance, the court shall proceed in accordance with law. However, before proceeding further, the court shall issue notice upon the respondent number 1 to 4 hearing. Who by defendant number? वो कौन defendant को वहाँ पर? Who by defendant number 1 to 4? Issue notice upon them before proceeding. It is further observed that the issues will be decided without being prejudiced by any observations made by the learned court in the improved order or even by this court by disposing of this case. That's all. Are you for? Are you opposed? This appeal is allowed. आप लोग अपना appearance दे देंगे.
For case filing item 4, the rupees 5535 of 2026.
Yeah, please, Your Lordship. Initially, Your Lordship, petitioner had challenged annexure 3. Before I come to annexure 3, Your Lordship, I will give Your Lordship's notice. I am a superintending engineer. By annexure 1, page 13. My name appears as serial number 14 at page number 14. I was promoted.
Serial number 14.
Page 14. कार्यपालक अभियंता ग्रामीण कार्य विभाग झारखंड राज्य विद्यमान सचिन सच को अधीक्षण अभियंता सुपरिटेंडेंट वेतनमान मिलने के पद पर प्रोन्नति प्रदान की जाती है तथा वर्तमान धारित पद को उनके पदस्थापन अवधि तक अधीक्षण अभियंता कोटि में उत्क्रमित करते हुए श्री कुमार को उक्त पद पर पदस्थापित किया जाता है. The post I was holding that was upgraded because I was holding the post of executive engineer.
Post was upgraded.
Yes, that post was upgraded.
Upgraded to SC.
SC. Subsequently, Your Lordship, by annexure 2, I got a regular posting. And annexure 2, page 17. My name appears as serial number 2. Shravan कार्यपालक अभियंता.
This is regular posting.
This is my posting. I got my posting on 18/5/2026. That is 2 months.
Yes.
Now, annexure 3 is issued by which I am agreeing, Your Lordship. Relevant would be page 20, by which the first serial number 9, Your Lordship. Sushil Kumar Sinha, कार्यपालक अभियंता, he is an executive engineer. ग्रामीण कार्य विभाग कार्य प्रबंधक दुर्गा को स्थानांतरित करते हुए अगले आदेश तक कार्यपालक अभियंता ग्रामीण कार्य विभाग कार्य प्रबंधक गिरिडीह के पद पर पदस्थापित किया जाता है. श्री सिन्हा अगले पद तक अपने कार्यों के साथ अधीक्षण अभियंता ग्रामीण कार्य विभाग कार्यालय गिरिडीह के अतिरिक्त प्रभार में रहेंगे. This is the post which I am holding. I got my posting on 18/5/2026.
And you have not even been transferred.
I had not even been transferred. Subsequently, I filed this writ application, Your Lordship. I serve a copy, 2 copies to them. Next day, after serving, next day they transfer.
Transfer you where?
That I challenged by filing ID number 10297. I have been transferred to Jharkhand. So the transfer order has been issued within 2 months, Your Lordship. Shravan Kumar, serial number. ये 22/7 का हो गया.
So merely because you have been transferred in 2 months, it becomes malified.
I am on malified, Your Lordship, because they have
Malified against whom?
General malified without jurisdiction, Your Lordship, because the fact is, to accommodate the respondent number 5, they posted by the include order, Your Lordship, in Section 3. That is very evident, Your Lordship. I was not transferred. I was holding the post of superintendent engineer DVD. He was given the additional charge. So to accommodate him, I am being transferred. If it was within 2 months, I would not have been agreed. But because to accommodate him, Your Lordship, after filing of this writ application, because the initial transfer order was 17/7/2026. I filed this writ application on 21st July and 22nd July.
You see, this transfer order will not come from the blue in 1 day's time. This transfer order is a proper decision taken at the secretary level. You are admitting malified because you have filed a
No, Your Lordship. The order does not show it has been taken at the by a department transfer committee. Order shows
झारखंड राज्यपाल के आदेश से
चिट्ठी
सरकार के उप सचिव
चिट्ठी निकली है मुझे, लेकिन
जैसे ऐसे तो नहीं निकलती है ना.
जो इनेक्शन 1 अगर देखा जाएगा तो जो प्रमोशन हमको हुआ था 26/12/23 को संबंध विभागीय प्रोन्नति समिति के बैठक की अनुशंसा पे. ठीक है. यहाँ पे जो है वो ऑर्डर निकल रहा है झारखंड राज्यपाल के आदेश से, क्योंकि अगर इंक्लूड ऑर्डर पे देखेंगे इंक्लूड ऑर्डर पे देखेंगे तो सबको सूचना के लिए दिया गया है, सूचना दी गई है, but there is no proceeding as
So
such.
where are you as of now?
I'm not given handed over my job.
See, prima facie, I am not satisfied with your case of malified. You can still call for a counter affidavit, but I will not grant you any interim. The law is well settled. If you are transferred, you join and then contest.
You understand? Generally, in the transfer order, it is written you have to join by such and such time. They have issued that transfer order in such a case to order. Nothing has been given.
Maybe nothing has been mentioned. It is your choice if you want to go, you go. But there is no question of any interim.
And I have also annexed Annexure 4, Your Lordship, which is the decision of the government,
That's
right, finance department, which says the additional charge of higher post should not be given. But by respondent number 5, who admittedly is holding the post of executive engineer, has been given the additional charge of superintendent.
Because you have been shifted.
Because I had to be shifted. I had not been shifted. I had to be shifted. He had to be given that charge.
Heard the learned counsel appearing on behalf of the petitioner. आपको क्या बोलना?
Total this is a routine matter, Lordship, since respondent number 5 has been
Sir,
given charge
Just a moment.
and thereafter
Just a
petition has been transferred, Lordship.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petition was filed on 21/7/2026 after serving 2 copies upon the state. And in the main petition, the petitioner had challenged the memo number 2727 dated 17/7/2026 issued under the signature of Deputy Secretary, Rural Works Department, Government of Jharkhand, whereby the respondent number 5 has been transferred from the post of Executive Engineer, Rural Works Department, Works Division, Dumka, to the post of Executive Engineer, Rural Works Department, Works Division, VDD, and has also been given the additional charge of Superintending Engineer, Rural Works Department, although the petitioner was already holding the post of Superintending Engineer, Rural Works Department, Works Circle, VDD at that point of time. and no transfer order of the petitioner was issued, meaning thereby the respondent number 5 was given the additional charge of superintending engineer, although the petitioner was holding the same post. She submits that immediately upon filing of the writ petition, the respondents have issued the transfer order of the petitioner from transfer of the petitioner to Jharkhand by notification dated 22/7/2026. The learned counsel submits that the petitioner had joined the post of Rural Works Department, DDD, only on
In pursuance to the notification.
in pursuance to the notification as contained in Annexure 2, which is dated 18/5/2026, and within a short span of time, the petitioner has been shifted to Jharkhand only to accommodate the respondent. The learned counsel submits that one interlocutory application has been filed challenging the transfer of the order of the petitioner from DDT to Jharkhand. She submits that the order of transfer having been passed only to accommodate respondent number 5 is tainted with malice, and therefore the writ petition as well as the interlocutory application seeking amendment is fit to be allowed. The learned counsel for the state has opposed the prayer and has submitted that the transfer order are routine transfers and there is no malice involved in this. It is just a matter of chance that the petitioner had filed the petition on 21/7/2026 and the transfer order was passed on 22/7/2026. The learned counsel has submitted that the petitioner was already required to be transferred and therefore a stopgap arrangement by giving in charge responsibility to respondent number 5 was made. The learned counsel for the state is directed to seek instructions and file counter affidavit on both the main writ petition as well as the interlocutory application. The state shall also serve notice upon the respondent number 5 through the office of the Deputy Commissioner दुमका. इसलिए आप वही है ना दुमका में कहाँ पे DDT में through the office of the Deputy Commissioner DDT, as the respondent number 5 is now posted in DDT. The counter affidavit of the state and that of respondent number 5, who is free to engage an independent counsel, be filed before this court by 7.
Next speaker. By 12.
Okay, by 12, post on 13. Before application has closed. The service report upon respondent number 5 should be filed along with the counter.
From date is for Canada School item 1, the rupee 873 of 2016.
Which judgment you said is covered?
कि उपेंद्र कुमार वाला जो जजमेंट हुआ था उसमें ये सर्कुलर जिस सर्कुलर पर इनका पूरा केस स्टैंड करता है उस सर्कुलर को कंसिडर करके आपने ऑर्डर किया था वो लोग सर्कुलर के डायमेंशन में आ रहे थे तो उन लोगों को आपने रिलीफ दिया था इन लोगों का केस ये भी उसी सर्कुलर के फुटिंग पर चल रहा है लेकिन इनका कवर्ड नहीं हो रहा है उस पीरियड में तो इनका केस को रिजेक्ट किया moreover I think that judgment is stayed it is state Roshan Upendra Kumar monetary benefit has been granted regularization part has been stayed
That is something that the solid.
so here it is only regularization they are already working
We are already working, we are under the scheme. The scheme is this scheme
So we have to wait for the judgment, no, otherwise there will be conflicting orders.
No. Can we consider that is a Supreme Court judgment as also the judgment by petitioner court?
Which has been stayed? Where is that order of stay?
That is not yet admitted also.
Maybe if there is a stay, that there is a stay. It is not necessary that case has to be admitted.
I have heard that there is an order to deposit the monetary benefit. Can you see that judgment? The judgment is to be covered by the LPA also. LPA Supreme Court decision Harinandan Tushar and another decision WPA.
ये तो आपका एक केस में ऑर्डर किए थे हरिनंदन प्रसाद का जजमेंट सब देखता हूँ.
Yes.
Where is that order?
That is I see that.
This Upendra Kumar.
Yes.
This order has been stayed. देखिए सर WPA number 7796 of 2012.
This case is fully covered under the
By which order? By which judgment it is covered?
That is fully covered by the judgment of the Honorable Supreme Court. Supreme Court LPA.
770
And in that case, I don't know whether any
7796 of 2012.
SAC number 29.
LPA 770 of 25
770 of 25. इसको जरा order निकालिए. LPA 770 of 25.
DT number 516 and 518 that is also covered.
and 318 of 25
318 of
25 order dated 17/3/2020
318 of 25.
17th March 318 2025 17th
Which order?
order dated order 17th March
17th March.
Para 9. Insofar as direction for regularization is concerned, we stay the same until the disposal of the and 50% has been deposited back. Admitted.
appear already.
Respondents are appearing before the court.
My submission is that, my lord, that this was for a reinstatement and regularization. My case is to be decided on the facts and circumstances.
No, that's right. So we have to wait for that judgment.
Let होगा
कब होगा वो आप जाइए ये में पूछिए कोर्ट से, हम तो नहीं बोल सकेंगे कब होगा। हम तो रखे थे आज डिसाइड करने के लिए, लेकिन इस तरह से कॉन्फ्लिक्टिंग ऑर्डर्स होने से बहुत दिक्कत हो जाती
ना conflicting order
है। Once the case has been admitted and there is an interim order, so case is under active consideration. Heard the learned counsel speaking on behalf of the parties. The learned counsel for the respondent submits that the order passed in the judgment passed in WPL number 7796 of 2012, wherein similar issue was involved as a subject matter of LP number 318 of 2025, wherein an interim order has been passed staying the regularization, the relief of regularization till the disposal of the appeal. The learned counsel submits that here the concerned workmen are claiming regularization. In view of the aforesaid facts and circumstances, let this petition be listed after disposal of LP number 318 of 2025 or on December 14, 2026, whichever is available. Yes, उसके पहले आप डिसाइड कराइए। ये फाइनल डिस्पोजल में लगा हुआ है।
Today
It is otherwise admitted.
it is otherwise admitted.
This case is
Let
for
this matter be listed under the heading for hearing. Liberty to make final disposal.
Item 2, the repeal 1504 of 2018 along with item 3.
Responding. Is that responding?
Responding earlier Ajit sir was also engaged in this matter earlier facing his appeal.
They are absent.
Sir is there. The present petition is directed against the award passed by the presiding officer, Central Government of Industrial Tribunal, Dharwad, wherein he has been pleased to direct the reinstatement of the respondent workman to the post immediately within 1 month from the date, and if not done, full back wages to be given.
If not done, then full back wages.
If not done within a period of 1 month, then to that particular period where there is a delay in reinstating that, for that period full back wages need to be given. This was the particular order. I may be permitted to show. So before going to that, the facts of the matter, I will just narrate the small facts of the matter, Your Lordship. The petitioner, the respondent workman, Kanhaiya Yadav was joined the respondent bank, the petitioner bank in May 1989 as a PU. May I finish?
Yes. Tell me. You are for the workman?
And I am for the bank.
I'm for the
You are for the workman.
Yes.
The inquiry was fair and proper.
Yes, the inquiry was held and proper. That is decided. That may be kindly seen from the page number, your lordship, it is there from the record itself, page number 171 of the writ petition itself. Page number 171. May I, your lordship? It starts from page 170. The order is dated 22/9/2015, wherein in page 171 it is of the same date. Later is written. May I read it? I'm reading it from page 170. Order dated 22/9/2015 from employer Shri Kanhaiya Yadav. WW1 examine, cross-examine and discharge on so-and-so Shri so-and-so for the work and submit that he closes his evidence. Third argument on preliminary point from both sides order reserved, and then on the later it is written from the evidence of the workman it is clear that he took part in the departmental inquiry. Therefore, it is held that the inquiry is fair and proper. Is your edition there? It's at the top of the page, page 171. So he participated in the departmental inquiry. He was given an opportunity of examination, cross-examination of the witnesses, and the inquiry was held and proper. And this particular order has attended the finality as it was never challenged. Now, the reference which was made, your ladyship, may kindly be seen from the impugn order. It is quoted page 172 itself. May I read? Whether the action of the management of Central Bank of India in terminating the service of the workman Shri Kanhaiya Yadav is justified on the basis of denying natural justice, what relief is entitled for. So this particular part, the natural justice part, the court itself has held. I may be permitted to read further para 2. Para 2, the case is received from the Ministry of Labour on so-and-so after receipt of the reference, both parties are noticed. The workmen files their written statement on so-and-so. The management files their written statement come rejoinder in the one witness from each side examined on preliminary point regarding fairness of the inquiry, and documents of management are marked as M1 to M14. The domestic inquiry held by the management fair and proper by order dated 22/9/2015, and order has not challenged by workmen. Now it is final. The case of the workmen, the entire case of the workmen is there, your lordship. Before going further, ladyship, I just wanted to point out a certain fact that the charge sheet was issued in that there were, apart from the workmen, the present workmen, other person was also named, that is S.K. Mishra. May I hear it?
No, you tell me what is your main point. Then
This
I
is
will
the main point, your lordship. The learned labour court has not considered anything, and just because in other matter, in the matter of the co-accused, one of the matter wherein they challenged the fairness of the proceeding, of the department proceeding, and this honorable court, at the then Patna court held that the inquiry was not proper and accordingly remanded back the matter for fresh consideration. On that basis, and later on, after remand, there was an order wherein he was held accused, he was held guilty, and that order has been settled, and that order is pending challenge before the Honorable Patna High Court. On the first order, your lordship, the operating part of the impugn order may kindly be seen, which is at para 14, page 175. This is the only crux of the order, your lordship, para 14. Can I be permitted to read that?
Yes, respondent, how such an order can be passed? They have to see as per section 11A. They were required to see as per section 11A. And demand it. Because we will not examine it for the first time here. The inquiry was said to be fair and proper.
That what I was indicating. Instead of giving the entire history, go by the
Yes.
impugn order.
And
Then we should be happy.
the other co-accused, yes, your lordship, the other co-accused, all the proceedings I have
Don't
annexed
bother
here
about
with,
it.
I have annexed the orders also of the different
We are
high
not
courts, your
concerned
lordship,
with it.
and
The
Yes.
court was supposed to examine your case in the light
Yes,
of
sir.
section 11A.
which has not been.
Right. The materials collected in domestic inquiry, then proportionality of punishment, etc., was required to be seen. That is Firestone done.
Yes.
That had
That has not been done.
Where is Firestone judgment?
Section. That judgment, I will be just giving.
Or the learned counsel appearing on behalf of the parties. This petition has been filed challenging the award dated 22/6/2017 during rapid election 19 passed by the presiding officer, Central Government Industry Tribunal number 1 Dhanbad in reference case number 7177 of 2014, whereby the learned tribunal has directed for reinstatement of the respondent workman to his post immediately within 1 month from the date of publication of the award in the official gazette, failing which the management has been directed to pay back wages to the workmen from the first day of publication of the award in the gazette. The learned counsel for the petitioner representing the employer has submitted that the domestic inquiry was held to be fair and proper by the order dated 22/9/2015, and that order has attained finality. Once the domestic inquiry is held to be fair and proper, the learned tribunal was under legal obligation to examine the case in the light of the provisions of section 11 capital A of the Industrial Disputes Act. The learned counsel has referred to the findings of the learned tribunal and has submitted that the learned tribunal has referred to the order of another person who was not found guilty.
He was also, he challenged the inquiry proceeding, two different inquiry with respect to both the accused pair.
With respect to the inquiry proceeding of another person.
Yes. And that he challenged wherein it was held.
And the said person had challenged the inquiry and certain order was passed by the Honorable High Court in this case. The learned counsel has submitted that the learned tribunal has not done the needful in terms of section 11 capital A of the Industrial Disputes Act. So far as the concerned workman is concerned, she submits that in that view of the matter, the improved award is perverse and cannot be sustained in law. The learned counsel for the respondents, though has opposed the pair, but does not dispute that the learned tribunal has not considered the case of the concerned workman in the light of the provisions of section 11 capital A of देखिए छोटे नागपुर टेनेंसी एक्ट में से निकल रहा Industrial Disputes Act. He has also, the councils are jointly referred to the judgment of the Honorable Supreme Court in the case of workman Firestone work. Citation बताइए. 1981.
3 SCC 451.
3 SCC 451 and have submitted that even if the domestic inquiry is held to be fair and proper, the needful is required to be done by the tribunal in terms of section 11A of the Industrial Disputes Act. After hearing the learned counsel for the parties and considering the undisputed fact that the domestic inquiry was held to be fair and proper, which remained unchallenged, the perusal of the improved award does not reflect consideration of the materials in terms of section 11 capital A of Industrial Disputes Act. What has been taken into consideration by the learned tribunal is in relation to another person
And the
who
parity,
suffered a different departmental proceeding.
yes, and the parity has also not been drawn or considered that whether the same parity.
This court is of the considered view that the learned tribunal has failed to exercise its power in terms of section 11 capital A of Industrial Disputes Act, and therefore the impugned award belongs to sustain in the eyes of law, which is hereby set aside. And the matter is remanded back to the learned tribunal for fresh consideration in terms of the provisions of section 11 capital A of Industrial Disputes Act.
This is the second serial number 3 in this particular
Just a
matter.
minute. The parties are directed to appear before the learned tribunal. I'll give a date of your appearance. Since the reference itself is of the year 2014, the learned tribunal is directed to decide the matter within a period of 3 months from the date of appearance the parties to court. Contempt का क्या करना है?
Second कैसा है हमारा?
हाँ, इसमें ही 17B cap, there was a stay earlier in way back in the year 2014 itself, and however during the pendency they filed the IA for recall and for 17A payment your lordship.
17B.
17B, I'm sorry.
Yes.
And that was allowed by order dated in the year 2024, which they have taken
Allowed by
contempt-
order dated?
allowed by order dated. Order dated 9/7/2024. Later on, your ladyship, this order was modified as we said that the workman has already retired and therefore we cannot till date. It was
Only 17B is only till the date of
till the date of,
superannuation.
and it
Till
was
the date of
so therefore
Yeah,
that
in
order was
purchase है क्या?
modified. And
This
we
is
have
in
also
purchase.
paid that amount for a short period of 6 lakh and all that we have already paid. So there is no
17
contempt. as-
17 contempt.
So drop it.
हाँ एकदम.
The learned counsel for the petitioners in contempt civil 870 of 2025 submits that the petitioner, the concerned workman, has no surviving rights. Accordingly, this
In
contempt
view of the
is
remand मतलब कहते हैं कि
in view of the remand.
order passed in first place.
Accordingly, the contempt proceedings are completed. Okay?
Right.
Item 4, WPS 7008 of 2023.
Only women's college in the area of Palamu. Showing that notice has been issued by the EPF for payment of 1,35,89,000.
How much?
1,35,89,000. You have deposited 50 lakh and or 55 lakhs in the
Who issued you the notice?
two issue.
Where is the improved order? EPF.
EPF
तो आपको तो देना ही पड़ेगा इसके ऊपर।
देना पड़ेगा मतलब कुछ लेटर्स है यूनिवर्सिटी का जो उनको हम ग्रांट्स डेट पे चलते हैं ग्रांट्स डेट पे चलते हैं और यूनिवर्सिटी का हमने रिजॉइंडर में लेटर लगाया था वी हैव रिक्वेस्टेड यूनिवर्सिटी इन द कोऑर्डिनेट बेंच दैट टू फाइल रिप्लाई टू दिस द रिजॉइंडर माय रिलेशन काइंडली सी द रिजॉइंडर में नॉट डेटेड फाइल विद द पिटिशनर में नॉट डेटेड 7/10/2025 R1 is the next page 11. ग्रांट से डेट मिलता है जो समय पे कभी नहीं मिलता, और ये लेटर से हमको मना किया गया था। although डेट इज 12/22, और सेवा में प्राचार्य गोपीनाथ सिंह महिला कॉलेज गढ़वा अनुदान वितरण के संबंध में उपलब्ध विषय के निर्देश आलोक में निर्देश सूचित करना है कि आपके द्वारा प्राप्त अनुदान वितरण विवरणी में भविष्य निधि कटौती दर्शाया गया, जबकि अन्य महाविद्यालयों के द्वारा ऐसा नहीं किया गया। आप भी भविष्य निधि कटौती को विवरणी से हटाते हुए नया अनुदान विवरणी लोन प्रति में शासी निकाय के सदस्यों से वर्ष सहित हस्ताक्षर कराकर अध्यक्ष छात्री के कार्यालय में उपलब्ध करावे। साथ ही साथ आपके द्वारा सकल पत्र उत्पादन द्वारा निर्गत संख्या 27/5/2022 में उल्लेखित किए गए अंतिम अनुदान का विवरण रेस्टोरेंट ढंग से करना सूचित करेंगे। इसमें इन्होंने कहा कि आप नहीं करेंगे, मेरे पैसे जो अनुदान से आप इसका भुगतान नहीं करेंगे। मेरे पास और कोई सोर्स ऑफ इनकम नहीं, मेरा अनुदान है। मैंने यूनिवर्सिटी इज साइलेंट अपॉन दिस लेटर।
बंद कर दीजिए अपने इंस्टीट्यूशन को, बंद कर दीजिए।
The only lady, only women's college in the
क्या
total
करें हम
5 districts.
You are
At
not
least-
able to run your
at least
institution,
university-
shut it down.
At least university should be asked to reply on this one. 1 week time. I'm not. If
Who
the
is
university will say,
responsible?
if the university will say that this is the situation, they will not allow us to pay for the EPF, then university will write.
Which
But
page
they will
did
be
you
asked to
read?
reply at least one query.
Which page did you read? Which
Mr.
page?
R1 will rejoinder to the reply on IA on behalf of the petitioner.
Page number बताइए
Page
ना।
number 11. First annexure R1. That
कौन
one
है
is-
ये यूनिवर्सिटी की तरफ से? बताइए। स्टैट्यूटरी ड्यूज बोलते हैं पेमेंट मत करिए।
ये सब प्रोफेसर ने क्या क्या लेकिन हिसाब से, लेकिन इसमें जो लिखा हुआ तो भी विषय के आलोक में निर्देशानुसार से सूचित करना कि आपके द्वारा प्राप्त अनुदान वितरण में भविष्य निधि कटौती दर्शाया गया, जबकि अन्य महाविद्यालय के ऐसा नहीं किया गया। अतः आप भविष्य निधि कटौती विवरण से हटाते हुए
भविष्य निधि विवरण को कटौती से हटाते हुए तो कैसे पेमेंट करेंगे?
पूरे
कहाँ से
ग्रांट
पेमेंट करेंगे?
ग्रांट डेट पे चलते हैं।
ग्रांट इन एड आपका कहाँ है? कॉन्स्टिट्यूशन कहाँ है आपका कि आप पूरा का पूरा ग्रांट इन एड
I
से
will
चल?
file my bylaws and everything, not what I get.
It's a government college.
It's a government aided college, no?
गवर्नमेंट एडेड कॉलेज में 100% ग्रांट इन एड नहीं होता।
I will bring on record everything not 2 weeks time. He may be, at least he should clear this position better whether the university is.
यूनिवर्सिटी देखिए, आप लोग कितना भी लड़िए, ईपीएफ अपना पैसा नहीं छोड़ेगा।
वो तो नहीं छोड़ेगा।
ठीक है ना? नहीं छोड़ेगा ना?
एकदम-
पूछिए इनसे।
एक बार खाली उन्होंने चूंकि कोर्ट ऑफ लॉ में है, बस एक बार चूंकि उस एरिया में कोई वुमेन्स कॉलेज, आई एम नॉट टेकिंग बेनिफिट ऑफ दैट कि हम वुमेन्स कॉलेज आपको चलने दिया जाए, आई कैन नॉट क्लेम दैट, बट एटलीस्ट माय यूनिवर्सिटी एटलीस्ट दे शुड क्लियर कि भाई आप साफ लिख रहे हैं कि किसी को नहीं जाता, आप क्यों करते हैं, आप हटा के आइए।
आप वहाँ से स्टूडेंट से पैसा नहीं लेते हैं?
बहुत नॉमिनल फी लेते हैं, लोग लेते हैं। आई एम रेडी टू फाइल एवरीथिंग ऑन रिकॉर्ड, एवरीथिंग आई विल बी ऑन रिकॉर्ड, व्हाट कितना अमाउंट लेते हैं, कितना फीस लेते हैं।
कितने स्टूडेंट्स आपके कॉलेज में पढ़ते हैं?
रिजॉइंडर कहीं पेज 5 देता है, मतलब पेज पैरा 15 देता है। ये स्टूडेंट का डिटेल दिए है, आर्ट्स साइंस कॉमर्स करके, पेज 5।
आपका तो इनटेक ही नहीं बढ़ रहा है क्योंकि आप किसी काम के लिए हैं।
बीच में मेरा
Nobody is
एप्लीकेशन
interested in-
कैंसिल हुआ था, हाई कोर्ट आया था तो फिर दोबारा रिस्टोर हुआ। दैट इज द रीजन आई विल ब्रिंग एवरीथिंग व्हाट आई गेट फ्रॉम द स्टूडेंट फीस, एवरीथिंग। एटलीस्ट ही मे बी डायरेक्टेड टू फाइल a specific reply to the that annexure, then things will be clear, you know. जितना पैसा था, I paid 65 lakhs.
आपका परमानेंट एफिलिएशन भी कैंसिल हो गया था,
वो भी रिस्टोर हो
उसके
गया,
अगेंस्ट में आप आए थे यहाँ।
रिस्टोर हो गया।
फ्रेश कमिटी करके इंस्पेक्शन करना था, क्या हुआ उसके बाद? कमिटी करके इंस्पेक्शन हुआ कि नहीं? कॉलेज आपका चालू हुआ कि नहीं?
चालू हो गया, चालू हो गया। तो कमेटी का रिपोर्ट भी लगा देंगे, आई विल ऑन रिकॉर्ड।
आपका ड्यूज किस पीरियड का है?
यूज तो 22 से पहले है।
तो फिर ये
ग्रांटिंग
तो
डेट-
22 में आया, उससे
एक
पहले
बात-
क्या कर रहे थे?
जितना जितना ग्रांटिंग डेट हमेशा नोटिस लेट में आता है, तो जब आएगा तब हम देते हैं। जब तक आया तो आई पेड 65 lakhs, इट्स नॉट माय केस कि आई पेड नथिंग, आई पेड 65 lakhs, दिस इज ऑन रिकॉर्ड। जब वहां से नहीं आता है वो लेट से आता है, और जब लेट से आता है और जब तक आता है तब तक कोई चिट्ठी आ गया था।
आपको असेसमेंट किए थे इनका?
7 assessment when Annexure 3 is there. Annexure 3 is the assessment order filed under section 7A.
इनको एग्जेम्पशन नहीं दिए हैं आप तो?
They are registered and they are paying, but they are paying in installments. And at such a total sum of 1,25,14,317 is still due.
आपका तो मार्जिन वाला हिसाब चलता होगा, कहाँ से खत्म होगा? तो कभी नहीं खत्म होगा।
नहीं, पेमेंट आप जब आए या रिकवरी के लिए
कहाँ
आए
से आएगा? जितना भी पैसा आएगा वो सब आप इंटरेस्ट पे जोड़ लीजिए।
That is the only
as per
What as per?
14 में damages and interest तो आएगा।
वो इंटरेस्ट पर ही तो आप लोग का ऑर्गेनाइजेशन चल रहा है, नहीं तो आप लोग किसी काम के थोड़ी। पूरा कहानी बैंकर और महाजन की तरह चलता है, हमें सूद मिले चाहे ना मिले, प्रिंसिपल मिले चाहे ना मिले, हमें इंटरेस्ट जरूर मिलना चाहिए।
जो इनका जो ऑर्डर जो हुआ था ये था रिलेटेड टू अक्टूबर 2012 टू अक्टूबर 2021। ये जो लेटर है ये 2022।
इतना लंबा पीरियड का आप एक साथ असेसमेंट कैसे कर दिए? इतना लंबा पीरियड का 2012 टू 2021, उससे पहले क्या कर रहे थे?
जो डिफॉल्ट आया, डिफॉल्ट को निकाल के हम लोग
इतना लंबा पीरियड
इनको नोटिस दिए, दे अपीयर्ड बिफोर द
Notice तो दिए, but is this the manner in which you pass assessment orders? And then you calculate the entire interest right from 2012. जान देंगे क्या पिटिशनर का?
Annexure 3 में मैम last paragraph है, on 2nd of February 2022 Dr. Sangeeta Kumari Singh, a complaint was received from the employee for non-compliance of employees provision of action. वहाँ से ही कंप्लेन आया है, उसी के बाद हम लोग नोटिस दिए हैं, and the principal
इनका कवरेज कब से है?
coverage 2008 से।
कहाँ से बोल रहे हैं? कवरेज
Annexure 2 show cause notice just page 31. Whereas the establishment Mrs. Gopinath Singh Mahila Mahavidyalaya has been covered under the Employees Provident Fund and Miscellaneous Provisions Act and the scheme framed under with effect from 27/11/2008, bearing PF code number so and so under section 1 subclause 3 subclause B of the EPF.
जब आपका 2008 से है, तो 2012 से क्या कर रहे थे?
We have received a complaint from the
Complaint, but they are already covered. Why do you need to receive a complaint?
If they complain
If they are already covered since 2008, where is the question of receiving a complaint? Yes?
after the receipt of the complaint, we inquired, and after that they
No,
have
no, there
admitted
is a
that they
question.
default.
You see, an organization is covered. So they are supposed to remit.
They are supposed
Automatically.
to deposit the dues.
What were you doing? 2012 से लेकर 2021 का एक साथ असेसमेंट कर देंगे, ठीक है? 100 रुपए का 1000 रुपए तो वैसे ही हो गए.
तो लिमिटेशन नहीं है मेरे.
लिमिटेशन तो नहीं है, लेकिन आपका ये किस तरह का कंडक्ट?
नॉलेज में आएगा.
नॉलेज में कैसे नहीं है? The organization is still in your radar since 2008. How do you say knowledge में?
नोटिस जो हम लोग दिए शो कॉज का, तो शो कॉज के नोटिस में भी ये लोग कोऑपरेट नहीं किया. एडमिट, they have admitted, the establishment representative admitted the default and submitted that dues for the period September 2013 have already been paid by the establishment. Now dues for the period April 2020 to December 21 has also been paid by the establishment. Sonu Singh and the employees of the establishment submitted that management is very negligent in its approach towards the extension of benefits up to the under the Act to its employees, and all actions for recovery of the dues and levying of penalty and interest must be imposed on the establishment as per provision of the Act. Last paragraph, page number 33 में. On 17/5/2022, Dr. Sanjita Kumari, principal of the college, appeared along with employees of the college, namely Dr. Kavita Kumari.
ये कॉलेज का प्रॉपर्टी किसके नाम से? किसके नाम से? The property stands in whose name? आपका ये इंस्टीट्यूशन बहुत जल्दी ही बंद होने वाला है.
R6 अपने रिक्वायरमेंट I have given details of each and 2008 से हम कितना पेमेंट कर रहे हैं, जैसे हमको फंड आता है हम पेमेंट करते हैं. I am regularly paying. हम पूरा R6 मेरा पेज 33 आप देख लीजिए.
नहीं, ये आप समझ नहीं
पेज
रहे
30
हैं.
पेज
ये आपके इस पेमेंट से कंप्लीट नहीं बनने वाला. आप करते रहिए पेमेंट, वहाँ में डालते रहिए पैसा.
I will bring on record each and every details of the account. This college is doing a pro bono work for the entire area. Not is only women's college. I am not charging. I will bring on record the schedule of fees of each or every year, every student. I will bring on record. I paid 65
We
lakh.
are not here hearing a mercy petition. Right? It is a statutory dues. You are bound to clear.
I reply there is a
इसको रिप्लाई करके क्या होगा? 2022 का चिट्ठी का.
उनको लेट से आता है. जब उन्होंने स्टॉप कर दिया कि नहीं यार कोई नहीं देता, आप क्यों दे रहे हो? व्हाई यू आर पेइंग? तो इनसे तो पूछ सकते हैं कि भाई जब पूरे एरिया का कोई कॉलेज कोई ग्रांट इनको नहीं दे रहा है तो हमसे भी और सबको तो भी एक्शन लिया होगा. इन्होंने लिया होगा. इन्होंने जब
बाकी सब कॉलेजेस में भी एक्शन लिया.
ना तो इनके तरफ से मना किया गया. उसमें है कि वो जो कॉलम है वो कॉलम को हटा दीजिए. दैट इज देयर इन द ऑर्डर. जो इनकी यूनिवर्सिटी से है, ये नहीं है कि डिडक्ट नहीं कीजिए. नहीं, वो ऑर्डर में नहीं है.
उसका मतलब भी वही होता है.
नहीं सर,
ठीक है, चलिए कोई बात नहीं. माय अंडरस्टैंडिंग
वो नहीं है. भविष्य निधि कटौती को विवरणी से हटाते हुए ये कहाँ दिया गया कि आप डिडक्ट मत कीजिए? हटाते हुए उसमें से ये कॉलम को आपको हटा देना.
बता देंगे ना, वो खड़ा वो तो बता देंगे. रिप्रेजेंटिंग द यूनिवर्सिटी ही कैन वेरी वेल से कि भाई
Do you deduct the amount from the salary?
ये दो भी खाली चले. मैं आगे इंस्ट्रक्ट आई विल फाइल डिटेल्स कि हम
If
क्या
you deduct the amount from the salary, you cannot say I don't have money to pay.
उस पॉइंट पे ले लेते हैं इंस्ट्रक्शंस. कितना इंशाल्लाह 2 हफ्ते के बाद उस टाइम पे ले लेते हैं कि भाई whether they have deducted or not from the employee salary. कितना अभी तक किया 2008 से लेकर अभी तक का पूरा डिटेल. और 2 वीक्स टाइम हमको दे दिया. और उस वीक में सिटिंग से भी अगर पूछ लिया था ट्रेडिशनल पे अगर कम से कम वो तो क्लियर करते हैं व्हाट इज दिस.
इसमें बहुत ज्यादा रोल नहीं रहता.
पूरा रोल यूनिवर्सिटी का है.
गवर्निंग बॉडी के द्वारा ये कॉलेज संचालन होता है. उनका अपना फंड आता है. हम लोग के पास जो स्टेट से आता है वो हम लोग उनको देते हैं जब जैसे जैसे आता है. इसमें हम 26 एक सप्लीमेंट्री फाइल किए हैं 6/1/2026 को. हम साफ साफ लिखे पैराग्राफ 8 में गवर्निंग बॉडी विच इज solely responsible to after all the administrative financial services related to statutory matter concern the teaching and non-teaching employee, and also regarding the payment of salary deduction, this deposit the EPF contribution. उसके बाद हम लिखते हैं कि answering respondent has no role play matter relating to EPF. EPF तो इनको अपने फंड से देना है, यूनिवर्सिटी को जैसे आता है वैसे दिया जा रहा है.
अब आप मेन ड्यूज भी नहीं क्लियर किए हैं, 7A का भी ड्यूज नहीं क्लियर किए.
इंस्टॉलमेंट से पे किए
7A,
फेमस कॉलेज है करवा.
7A इन्होंने जो पेमेंट किया आपने एडजस्ट कर लिया.
हाँ एडजस्ट करके आप काउंट फाइल किए 1 crore 25 lakh is still due.
पीरियड का कहाँ से, पीरियड कौन सा?
पीरियड वही
12 से
12 से 21.
भाई 12 से 21 तो था ड्यूज, इस बीच इन्होंने 67 या 68 लाख पेमेंट कर दिया.
that is
तो
with
आपने
interest.
किस ड्यूज में, कौन से साल के ड्यूज में एडजस्ट किया?
जो 7A का ड्यू 7A में जो इंटरेस्ट में आएगा वो इंटरेस्ट में आ जाएगी.
तो आपका कहाँ है फ्रेश शीट
फ्रेश शीट में ग्रैंड टोटल
आफ्टर एडजस्टमेंट?
ग्रैंड टोटल फाइल कर देते हैं.
ग्रैंड टोटल नहीं पूछ रहे हम आपसे,
Separate
कौन
में-
से साल का? अगर मान लीजिए हम पेमेंट किए हैं तो 2012, 13, 14, 15 हो सकता है इसका ड्यूज क्लियर हो गया हो.
वो फाइल कर देते हैं. सेपरेट शीट में फाइल कर देंगे 7A का कितना आ गया, 7Q में क्या है, 14Q में क्या है, वो स्पेसिफिक डाल देंगे. क्या ग्रैंड टोटल ये 1 crore 25 lakh is there.
और आपका मीटर ऑन है. अटैच करके खत्म क्यों नहीं करते?
अटैचमेंट का था स्टे हो गया था.
यहाँ से स्टे है.
अटैचमेंट का नोटिस दिया था उसके बाद ये लगा.
क्या होगा आपका केस में? कुछ नहीं होने वाला.
एक बार इनसे सीट मार लिया जाए, मैं रिकॉर्ड लेते आता हूँ कितना हमने डिडक्ट किया, एक बार यूनिवर्सिटी से पूछ लिया जाए, इज द इंटरेस्ट ऑफ द सीरियस होता है कि मैं पूरा से रिकॉर्ड लेते हूँ.
एक इंस्टीट्यूशन चलाने नहीं सकते हैं, खाली वहाँ लूट मचा रखते हैं. पता चलेगा कि टीचर से कम तो स्टूडेंट है थोड़ा दिन में.
स्टूडेंट है
कहाँ है स्टूडेंट? स्टूडेंट सबको दिख ही रहा है. ये कोई स्टूडेंट है 2022 में? पहले 2014 में 644 आर्ट स्टूडेंट थे, अब 2022 में 477 आर्ट स्टूडेंट. ठीक है, पहले 2014 में 62 साइंस स्टूडेंट थे, अब 21 साइंस स्टूडेंट्स हैं. पहले 2014 में 45 कॉमर्स स्टूडेंट्स थे, अब 11. तो 11 तो टीचर होंगे और 11 स्टूडेंट हैं. यही है ना?
इसमें जो
ये बंदी होने लायक है इंस्टीट्यूशन.
एप्लीकेशन खत्म हो गया था, इसलिए ये
2022 की बात कर रहे हैं हम. What is this? Are you running an institution?
उस एरिया में बहुत मुश्किल से
एरिया क्या है? एरिया आपके चलते और खराब हो गया.
हम तो पढ़ाने का काम कर रहे हैं.
कुछ नहीं आप पढ़ा रहे हैं. 11 कॉमर्स के टीचर हैं और 11 स्टूडेंट. 21 साइंस के टीचर हैं और 21 स्टूडेंट.
मैक्सिमम आर्ट्स के
एक स्टूडेंट के पीछे एक टीचर, फिर भी आपका रिजल्ट 0.
उतना ही क्या साइकोलॉजी पेंडिंग होगा 2 दिन.
दिख रहा है नंबर ऑफ स्टूडेंट्स घटते जा रहा है. आपका तो क्लोजर का टाइम आ गया.
मिल जाएगा पेमेंट का टाइम, बट एक चांस लेते हैं आप. फाइल एक एंड एवरी डिटेल्स पूरा अकाउंट फाइल कर देते हैं. क्या
उससे हमको क्या मतलब है आपका अकाउंट से? हाउ एम आई कंसर्न एंड हाउ आर दे कंसर्न? आप तो रिटर्न में नहीं फाइल कर रहे हो.
नहीं फाइल कर
कहाँ से फाइल कर रहे हैं? कुछ नहीं कर रहे हो. इससे इंस्टीट्यूशन का कोई फ्यूचर नहीं है. जितना जल्दी बंद हो जाए उतना अच्छा है. नया इंस्टीट्यूशन खुले.
उस एरिया में गढ़वा एरिया के मुद्दा भी नहीं है.
गढ़वा में नया प्राइवेट यूनिवर्सिटी खुल गया है, बाबू दिनेश सिंह यूनिवर्सिटी. डेंटल कॉलेज, मेडिकल कॉलेज सब खुल गया है.
Learned counsel for the petition submits that the petitioner has no source of income apart from the aid received by the university
और फीस तो मतलब
and nominal fees collected from the students. Since there has been delay in remittance of aid from the university,
And
there has been
departments, yeah.
delay in remittance of provident fund amount to employees provident fund organization, which has resulted in accumulation of huge dues. The Learned Council has referred to the rejoinder dated 7/10/2025 and paragraph 15 of the rejoinder shows that the number of students in arts, science and commerce reduced from 644, 62, 45 to 8 to 477, 21 and 11 in the year 2022. And the grant in aid was stopped during the period from 2017-18, 2018-19 and partially given in the year 2019-20. And the petitioner has paid substantial amount to employees provident fund organization to the extent of rupees 61,54,390 out of the demand of rupees 1,25,14,317. He has submitted that a letter dated 5/8/2022 as contained in annexure R-1 has been issued by the university, and according to the petitioner, the university has asked the petitioner not to deduct/deposit the amount towards the dues of EPF. He also submits that the respondent university be asked for to respond to the annexure R/1 as contained in the rejoinder. The Learned Council for the respondent university is directed to seek instructions and respond particularly to annexure R/1 to the rejoinder. आपको जो बोलना है. However, the Learned Council for the university has submitted that the petitioner is being run by a governing body and is an independent organization and is not dependent only upon granting aid by the university. They are also supposed to collect fees from the various students and make the institution self-dependent. There is neither any order nor can be any such order asking the petitioner not to deduct/deposit the EPFO dues to the concerned organization. बताइए कब रखें? बस आज पहला ही दिन टाइम दिए, अगला दिन हम टाइम नहीं देंगे. समझ लीजिए इसको अच्छी तरह से.
इसको 4 weeks करना है. इसमें ना वो ग्रांट एंड एड जो आता है वो डिपार्टमेंट से आता है, यूनिवर्सिटी से नहीं आता है. हायर एजुकेशन डिपार्टमेंट से आता है.
The grant in aid is being forwarded by the Department of Higher Education, State of Jharkhand, and it is given to the petitioner through the university. Higher education भी तो होगा. इस institution को बंद क्यों नहीं कर देते? हाँ? या तो रखिए या मत रखिए.
इनका अपना इंटरनल रिसोर्सेज है. टीचर का डिडक्शन कर इनका होता है. ये नहीं जमा करेंगे तो उसके लिए ये नहीं रिस्पांसिबल हैं.
बंद हो जाएगा.
बंद कर दिया जाएगा.
The Learned Council for the state has submitted that they are not responsible for default on the part of the petitioner with respect to the dues which is payable to employees provident fund organization. He submits that it is the statutory liability and the petitioner is bound to clear the dues as per law. चलिए हो गया आपका काम। बताइए कौन सा दिन आपको सूट करेगा? शुभ दिन बताइएगा।
आज तो मंगल है।
हाँ बताइए। बताइए आपके लिए शुभ दिन कौन सा होगा? Post on 18th in the supplementary clause list.
Lordship may appreciate. My delivery said in the year 2024 compensation award, there is a stay. And yes, one IA and there is a stay one. And now this day 2 साल हो गया, मुझे कोई पैसा नहीं मिला और इसको सुना नहीं तो किस सप्लीमेंट्री में कर लिया कभी भी रख दिया जाता या फिर हमको पेमेंट के लिए ऑर्डर कर दिया जाता। 2024 में लॉर्डशिप ये ऑर्डर डेटेड 9/6/2024।
उसके अलावा ये क्या है?
मेरा एक
गोपाल सिंह महिला कॉलेज, ठीक है, उसका ये फर्स्ट अपील है, एडिशनल एविडेंस। व्हाट इज दिस एडिशनल एविडेंस फर्स्ट अपील? आपका है?
नहीं,
Okay, 5.
5 नंबर
I will tell you.
क्या है ये एडिशनल एविडेंस का कहानी आप लोग का खत्म नहीं होता है?
नहीं, इसमें on account of subsequent events.
कितना दो ये है?
I am not pressing. Some of
Which
the
are you not pressing? बताइए कौन सा नहीं प्रेस कर?
4496 of 2026.
The learned counsel for the applicant submits that he does not want to press IE number 4496 of 2026.
Some of the important documents,
Additional.
some of the important documents could not only therefore fresh IE.
He submits that some of the important documents could not be in it and therefore fresh utility application being IE number 8192 of 26 has been made. क्या फोटोकॉपी फाइल की है क्या?
नहीं, ओरिजिनल लगा।
क्या क्या लगा दिए?
Voter ID card. In this question is this only may consider that whether the Mathur Mandal and Vishnu Mandal are the same person or not. According to the defendants, Mathur Mandal and Vishnu Mandal are the different person. But your lordship will see the document that it will be proved that Mathur Mandal and Vishnu Mandal are the same person.
ये सारे डॉक्यूमेंट्स उस समय क्यों नहीं लगे?
नहीं, उस समय on account of subsequent अभी हम लोग
What subsequent development? उस समय आपके पास वोटर आई कार्ड नहीं था क्या?
नहीं, उस समय कुछ हम लोग से भी गलती हुआ है, हम लोग लगाए नहीं
गलती सुधारने का कोई
नहीं, जजमेंट भी देते 2022 को सुप्रीम कोर्ट का है।
क्या?
ड्यू डिलिजेंस नहीं भी है, अगर वो डॉक्यूमेंट से अगर जजमेंट हो सकता है तो उसको हम लोग लगा सकते हैं। 2022
आपको कोई डॉक्यूमेंट का जरूरत नहीं होता जजमेंट करने में।
जरूरत पड़ेगा इसमें। ठीक, उस दिन
आप रिस्पॉन्ड कर दिए? The learned counsel for the respondents pray for and is granted 2 weeks time to file reply to IE number 8192 of 2026. It has been submitted that the interlocutory application seeking to adduce additional evidence is required to be considered along with the final code.
at the time of hearing.
Post on 10 September. इसके बाद ये क्या है? 6 first appeal anthrax pigments. ये क्या चीज है? Who is appealing for the appellant? आपको क्या चीज के लिए टाइम चाहिए?
मुझे इससे आ गया पास उसमें पेंशन उस तारीख से
2 हफ्ता आपको एलसीआर देते हैं बेटा।
इसमें हम एक पार्टी ऑर्डर हो रहा था वहाँ पे
पार्टी हो रहा था कि हो गया?
क्या है मतलब वो सबसे कम PWS थी फिर के एविडेंस वगैरह हमारे पास नहीं तो हमको सिर्फ एलसीआर देखना पड़ता है।
Specific performance of contract में इतना लंबा टाइम नहीं है।
Specific performance which are automatic clear for return of money. The specific performance was dismissed and the amount that
You are not interested in money.
But I am interested in money only.
तो आपको किस लिए टाइम चाहिए?
LCR हम एक बार देख लेंगे जो प्राइस में ना तो हम assess कर लेंगे।
LCR का स्टैम्प कॉपी है? चलिए आपके घर तक LCR पहुंचा देते
हम देख
हैं। पेन ड्राइव लेके आइए, लाइए अभी देते हैं आपको गिफ्ट में हाईकोर्ट की तरफ से।
रिस्पेक्ट कर लेते हैं।
खाली टाइम लेने के लिए जो है ना यहाँ पे टाइम नहीं है, ठीक है?
2 सप्ताह बाद पर करेंगे।
2 सप्ताह बाद क्यों रखें इसको? अब इसको हम एडजर्न कर देते हैं, यूजुअल कोर्स में आएगा 10-20 साल बाद में कब, ठीक है? 2 weeks, why 2 weeks? नहीं नहीं, इतना टाइम हम नहीं देते। केस रेडी है, बहस करें, इतना टाइम हम नहीं देते। At the request of the learned counsel for the appellant, the matter is adjourned and is directed to be posted on next Tuesday. No further adjournment will be granted. It will be open to the council for the parties to. आप लोग अपने इसमें ऑर्डर क्या करना है? जैसे पेन ड्राइव लेके अपना सारा रिकॉर्ड चाहिए, आपको जितना रिकॉर्ड चाहिए, LCR सारा स्टैंड हो गया। बीच पे अभी रुकिए, बेचारे वो बैठे हुए उनके तक पहुंच नहीं पा रहे हैं। हाँ बताइए।
Item 7 लॉर्डशिप।
हाँ क्या है 7?
मैंने IA फाइल किया फॉर वैकेटिंग द स्टे।
अरे भाई स्टे तो ठीक है, क्या स्टे हुआ?
इसमें कि हमारी कंपनसेशन अवार्ड हुआ तो उसको स्टे ले लिए।
इम्प्यून ऑर्डर कहाँ? क्या व्हाट इज द नेचर ऑफ इम्प्यून ऑर्डर? व्हाट इज द नेचर ऑफ इम्प्यून ऑर्डर?
इम्प्यून ऑर्डर में मुझे पेमेंट करने के लिए बोला गया है एम्प्लॉइज कंपनसेशन अवार्ड।
अच्छा, एम्प्लॉइज कॉम्पनसेशन।
यस।
एम्प्लॉइज कॉम्पनसेशन के अगेंस्ट में क्या WPL होगा?
नहीं होगा, अपील
तो
होगा,
फिर
लेकिन
कौन फाइल कर दिया है?
फाइल कर दिए। सेक्शन 30 जो है एम्प्लॉइज
This writ
कंपनसेशन
petition is not maintainable. Where is the appellant? Where is the petitioner?
an appeal lies to the high court from a specific order of
नहीं
a
ये तो है, maintainable ही नहीं है।
और हमारे स्टे ले लिए।
कौन है petitioner? Employees compensation में तो सीधे appealable order है।
Yes, that's the limited issue to the interference of the 226.
Section 30 का अपील फाइल होता है।
Yes.
So regular appeal writ petition में कैसे होगा? The learned counsel for the respondent has submitted that he has filed interlocutory application for vacating the order of stay.
IA number 11660.
So IA number
11660.
11660 of 2020. He submits that the writ petition itself is not maintainable, and the petitioner ought to have filed regular appeal in terms of section 630
30 of that.
of the employees compensation case का act का नाम बताइए पूरा।
Employees Compensation Act 1923.
नहीं वो तो वर्कमैन्स कॉम्पनसेशन एक्ट, इसका नाम चेंज हुआ था ना। ठीक है, एम्प्लॉइज कॉम्पनसेशन एक्ट। Since the appellant petitioner is absent post tomorrow, इसे साइन को खत्म कर दीजिए। ये नहीं चलेगा, लीड नहीं चलेगा इसमें।
Much of
It is an appealable order. Yes. हाँ बताइए आपको क्या डिमांड्स?
Serial number 15 should be posted tomorrow for subsequent because the reason why it is coming for orders is that there was an IA file by the appellate for the respondent number 8 because he was not appearing. Paper publication was done by the order date is 7/11/25. Thereafter it has not been listed. They have also filed the supplementary paper publication has already been done, but they are not appearing. Let it be proceeded without the implementation because I am representing all of the rest of the respondents.
So who was not appearing?
Respondent number 8, one of the respondents.
Respondent number 8.
Yes. Several notices have also been issued, paper publication has also been done, there are
So therefore the service is complete.
services. But since the appellate is not there, let it be done in
So correct.
this case.
At the request of the land guarded counsel for the respondent, serial number 15 को post this question. देख लेंगे आप फिर ऑर्डर पास कर देंगे
Yes,
लेकिन सुनवाई का अभी नहीं होगा
at least एक stage आगे बढ़ जाएगा.
एडमिट कैसे
हाँ.